So thank you everyone for joining. My name is Girish Shankar. I lead strategy at CAMS. I also run a couple of businesses, and it is a pleasure to host all of you on this DSPM as a first step to DPDP implementation. So just to set some context before we go on to the panelists. So it's been a little more 4 months. It's been a little over 4 months since the DPDP rules were notified in November. And by now, I guess most of us are familiar with the law and the interpretation, and it's time to move into implementation, right? I mean, how do we go about the entire piece? Most of the discussions which we see, which happen out of the webinars or panel discussions, largely focus on the concept of consent management. But when we speak to clients, when we speak to other partners, what we realize is organizations are struggling with a more basic question. Do I know where what kind of personal data I hold? Do I know where it resides? I have it in my backups, I have it in my structured databases, I have it in Excel, I have it in people's desktops. So what is my posture right? And how do I go about managing that entire thing? And that's why this topic becomes very important. Before we actually talk about the consent frameworks and the kind of governances which we have to put in place, organizations must first try and understand their data reality roadmap. Let me put it like that. And I have a very capable panel to discuss this, and it will be my pleasure to introduce them in no particular order. So I have with us Arun Prabhu. Arun is a partner with Cyril Amarchand Mangaldas, and he is also the co-head of the digital and TMT practice. He advises organizations extensively on complex matters relating to IP, data protection, and privacy. We also have Mr. Vipender Man. Vipender Man is a senior partner and the co-founder of K&M Partners. He works extensively at the intersection of law, AI governance, and data protection. And finally, we also have Kaustubh Shakarwar, who is the founder for Data Nuance. And they advise startups on privacy practice, IP, and emerging technologies. The panel is a very experienced panel, both at the law and the legal aspects, as well as on the practical aspects of data privacy. And it will be a pleasure to interact with them and get more insights into this. So without much further ado, I'll just start the panel discussion. And my first question is to you, Arun, and thanks for joining. So Arun, today, most organizations are still trying to interpret DPDP, right? And it's from your perspective, what are the most common misconceptions that companies have about DPDP compliance? I mean, where are they overthinking about DPDP, or where are they underprepared? I mean, what is your view based on your discussions with multiple organizations?
No, so you've stolen my thunder. Like you said, I think people are focusing far too much on a lot of the details around how consent is basically jurisprudential queries, right? Because it excites us all. We're all lawyers, whether we like it or not. So whenever there's a concept of, oh, will this consent be okay? How is it going to affect my life? Will this process work? Will that process work? That's the kind of thing that gets a lot of eyeballs. Just like in any AI conversation, you will almost inevitably turn into what will happen if AI takes over the world. But on the DPDP, I'm actually very fond of saying that the DPDP is not one law, it's actually many laws. It affects you very, very differently based on whether you are a small B2B enterprise, which largely connects data of your employees, and very, very differently if you are a B2C enterprise, which has hundreds and thousands of data sets of individuals on your books. And strangely enough, in India, people don't even know the difference. We don't have a data culture today. We've never had to track how much personal data we hold, unless, of course, you're in the financial services or regulated business where the regulator has had some kind of eye on it. You've never had to track it. So a lot of places, you simply don't know what you have. A classic example is hospitals. They often have either legacy repositories or filing cabinets full of hundreds and hundreds of thousands of records of people, and rich, context-rich, identified, structured records, including disease data, payments, claims, etc., etc. Government is another example. They have never been exposed to a general data protection regime. They are discovering what they hold today. So at its core, depending on the size and scale of your operations and how much data you hold and process in the course of your business, this can be a very different law for you. One example, of course, is the significant data fiduciary threshold. Size and scale of processing is one of the important markers that the government of India will use. And if you look at the conversation around acceleration of parts of the DPDP, it is largely focused on making information requests to understand what data you hold, to decide whether you're going to be significant or not. And if you're significant, of course, the law changes very differently for you. It starts looking a lot like GDPR if you're a significant data fiduciary. So I would say organizations are overthinking to some degree the how, but they're not really spending too much time on the what. And the what really comes out of having a clear and tangible map of your data. Often, if you actually take it high enough in the chain with a clear enough map of your data, and we've done some of this with you and your group, Girish, it's often simple to look at it and say, hey, do we really need to do this processing? Is this activity really necessary? Is it core to my business? Rather than scoping and spending the time and effort it takes to actually get consent or whatever else you have to do to enable that processing.
So that's interesting. Yeah. So just before we go further, Vipendra, and the question is to you because we have the topic called DSPM. So what is DSPM? Can you just help translate it to the people on this call? I mean, what is DSPM and what does it mean in the context of DPDP?
Yeah, thanks, Girish. Actually, this term was, I would say, coined by Gartner in 2022. So that's first thing we should understand where this term is coming from. And basically, this is a technology or a tool which identify your sensitive data, and then it also identify the sensitivity in terms of security, in terms of compliance, in terms of its vulnerability, and it tracks your entire systems, your cloud, everything. And then it can identify what data, what kind of data, where it is parked in your systems, and what is the basically sensitivity and how you are going to comply with it. And it depends on the tool, which tool. Basically, there are tools which only identify or visualize your data, and there are tools which can take you from starting from discovery, that is visualization, to mapping, and then compliance also, and also security, take care of security. When it comes to the context of DPDPC, we are looking at I would say, marriage party, and the world has seen kitty parties till now in terms of data privacy. Basically, we are looking at 1.4 billion data principles. Everybody is a data principal. So such a vast scale, I don't think it is humanly possible to manage it with Excel sheets or by creating some privacy policy or some other policies which you keep in your folders. So you need some tech solution to handle this kind of massive, humongous exercise. So in that context, you cannot escape from some kind of technological intervention. Rather, I would say it is a techno-legal problem, and it is a design problem than a simple legal problem where you just have to do some compliances simply. So you have to look at your systems in a different way. So that is where this context to DSPM comes in terms of DPDP. So I don't think you can comply with DPDP without getting into some kind of tool. I hope I addressed the
Yeah,
question.
I mean, I'll possibly double click on this and come back to you a little later, just to go back on how we can go about it. But before that, Kaustubh, I know you work with a few organizations, a lot of organizations, in fact. And when you work with them, how common is it for organizations to actually have a complete map? I mean, what has your experience been? I mean, do they really have it in place, or how do they come across?
It's a That's a great question. First of all, thank you for the invitation. Thank you for organizing this. It's obviously a great opportunity to be alongside Mr. Man and Mr. Prabhu. Just to answer your question, I'll give you a longish sort of an answer to it. When you usually get into organizations and you start a compliance exercise, or at least my experience has been so, is that when you work with, rather than an entire organization, you work with stakeholders who are managing a certain project or the compliance exercise. What's interesting is most of these stakeholders are usually supplemented from different teams. So it's a mix and match of teams. Now, each one of them have experiences or exposure to their systems. So each cog in this piece will have exposure to their systems, and they'll be familiar to what they do. So in their 8 hours, 10 hours of their workday, they interact with systems in a certain predictable manner. And therefore, when you start the exercise, it feels like, hey, I know everything. This is my system, this is my map, it's just this, right? But to answer your question, do they actually know? And the answer is no. Most of the times what happens, these systems are legacy systems. There'll be somebody who will come in, work on a bit of something, and they'll move out, and then somebody else will come and take over that project and move on. Either it could be as simple as something like a CRM, with something simple as like a in-house feature. Somebody it's so there is very rarely a particular human being system or a direction file which has all information from start to end of that project. And therefore it is always a surprise for everybody to know that, hey, oh, okay, there is much more than this in the organization. My exposure was only say 20, 30%, 40% of the entire systems. And whenever there's a legacy change, there is usually systems and databases and files, and especially PII, that gets left behind somewhere, and nobody knows how to clean that up, because that was never part of the project in the first place. And so when you start with the exercise now, especially in the climate right now, it comes as I would not say surprise, I'll say it comes as a shock most times, that there is a lot more information that exists in an environment or in a company or in a system than what everybody is familiar with. So that's my outlook to it.
Great. So it's interesting. So essentially what we hear from the panelists is that today most organizations, like Arun pointed out, are getting into the deep end of the pool and working about consent architectures without having a sense on where they are, right? And first, to get a sense on how you are currently structured, that's the first step, which is important step. And it is impossible to do it manually through Excel files, given the legacy systems and the fact that a lot of handovers and takeovers would have happened, and hence the need for a techno tool like Vibinder put it to kind of help you get this process started. So and that's where this entire concept of data security posture management comes in. Great. So before we just go to the next section, I think we also have a short poll which is for the audience over here or the attendees. I will request Meher to put it up on the panel, and please do take the poll. It will just give a sense on where you are in terms of this entire DPDP exercise, and of course it will be treated so.
Can
So
I also
just
answer
coming
the
to the
poll?
second. No,
Are we also supposed to
everybody.
answer? Okay.
No. It's for everybody who's on the who's on the Teams chat. Great. So just Vibhinder, coming back to you, and you just broadly told us what DSPM means. Could you just give us a flavor of what it practically involves? I mean, what should organizations expect, or how should they be prepared when they begin this exercise?
Thanks, Girish. Actually, I think to begin with, there should be a internal DPDP compliance committee, which should comprise of everybody who is internal data fiduciary, legal team, risk management, and all the relevant stakeholders who are getting affected or are going to be involved in this exercise later on. It is not necessary to identify everybody at the beginning, but at least to start the mapping and visualization or data discovery, I think there is somebody who should own this exercise. So that is first step. And then after that, if you look at the technical part, this exercise starts with data visualization, or you may call it data discovery, which is the most common term used. So the first part is where all the data is parked within your systems and clouds, wherever. And this exercise basically is going to be very amazing exercise when you will find that you are not even aware of this kind of data was in the systems, and it was, you can say, some people call it ghost data, or you may term it anything else. So that is the first part of the exercise. Once you identify the data, then next, this data is as of now only identified. So next part is it is linking this data to the DPDP compliance, in a way, logic, which is whether this data is parked in the system because of legitimate use or because of some consent. So what is the legality of this data? How this data is with you, and whether this data should be legally within the system or not. So that is where the mapping part comes. So these are the two initial parts. Once this is done, then there are some systems, DSPM, which can handle your compliance also, then consent and other things come. So initial part is data visualization, data discovery, and the second part is mapping. Without mapping, you cannot really understand what this data is about. And here we are talking about digital personal data primarily, because that's what we are going to look at in DPDP compliance.
So, fair point. So, first is you should have an owner for the entire exercise, and then start the process and add as we go about. Great. Uh, and before I come to you, Arun, Kaustubh, a quick question. I mean, what kind of blind spots should we expect? I mean, where do companies typically find the biggest surprises once they start mapping their data? What should be their next steps once they do that?
Absolutely, that's a great question. I think surprises before data mapping. I think the maximum surprise comes before the data mapping exercise, where where the organization is still trying to figure out why data mapping. Why is that the first question? It works. It's the other side of the coin is the surprise to the data mapping, which is as Mr. Van said, is a lot of ghost data, a lot of legacy systems. So to identify and understand where these data sets lie is a question. For example, say the marketing team will have multiple sets of personal data. They'll have a database of people to send, say, an email to of January 2025. It'll be some legacy data of say December of 2022. So the surprise that comes is usually the multiplicity of data sets that actually exist within the systems, which are beyond this familiarity. And what happens is that another place where I see there's an element of surprise is just the ambit of the DPDP, right? So as Mr. Arun said, it's a multiplicities of laws. It's not one law. It's so many laws. There's so many things to be done. So when you're doing a data mapping exercise, you tend to also see the touch points of data with the systems, right? So where it's incoming, where it's outgoing, who is interacting with it, and all of these touch points also will form sort of your base in understanding where your compliance structures actually have to be implemented. So it goes in both ways to understand where your sets of data lies and what are your ghost data, as I said, and to identify that, okay, these are these 4, 5, 7, 8 touch points, and therefore a compliance exercise will have to take into consideration these things is the main sort of surprise. I hope I answered your question.
Yeah, and sorry, I'll just also add, because we did this exercise a little bit and we found, so we also have data on tapes. So there is a regulation which says that you should take data backup on tapes, and the tapes lie in some storage vendor. So and then you have backups, and you have DR sites, and you have data backups which go into your air gap centers. So Traditionally, these don't come in the purview when we start looking at it, and now suddenly we realize we have a whole lot of places where we have to look at. Yeah, so that is just something. And so, Arun, so given the complexity of just trying to find out where data is, where your personal data is, what kind of personal data you hold, just curious, what are the kind of legal liabilities that we or a data fiduciary is exposed to if they cannot prove that I know where my sensitive data lies?
Sure. So I think, I mean, you asked the question very correctly. I think the lens is very different for a significant data fiduciary and a regular data fiduciary. As a significant data fiduciary, like I mentioned, this law starts looking very onerous. It looks like a full-fat version of GDPR, but with some very uniquely Indian tadka on top of it. That Indian tadka includes no data classification. So it's a flat structure. You're protecting your name and phone number at the same level as you're protecting your cancer diagnosis. It's a very flat structure. That's a global outlier. Second, you have a very, very fiduciary centric regime. Very little statutory devolution is possible to any processor. Third, you have this very unique creature of an organizational data protection impact assessment. Impact assessments on single applications or single procedures run into 20,000, 30,000 rows. Now, imagine doing that for an organization at any sort of scale and complexity, to say nothing of organizations of your own scale and complexity. Well, I'm sure Kaustav will enjoy playing with fields of that complexity and size from an intellectual perspective. As a business outcome and just in terms of being able to grapple with it, it's a massive exercise. Then you have this audit, which is almost, I mean, I don't know if it's a data protection audit or a statutory audit or a combination of the two. Auditors are very comfortable with doing an information security or PIMS sort of audit for 27,001, 27701, but it'll be the first time they're doing a statutory audit on a piece of law. Then you have undefined, sorry, I know I'm going on, but there's so much. You have an undefined set of government exclusions, which are very broad and yet very narrow. So you have the ability for the government to literally ask you anything, but you don't have an ability to disclose it automatically unless it's a disclosure mandated by law. So it's a very, very interesting situation for significant data fiduciaries in India, a lot of whom tend to be heavily regulated as organizations. They tend to have some regulator who's looking at their business in a day-to-day basis, and that regulator is usually not mighty. So given that history, given that background, our sense here is that as a significant data fiduciary, the least you can do. So one, it may not be a question of if you will fall afoul of this law. And sorry, last point, it's a 14-page law. Parts of it are written less clearly than others. I mean, if the GDPR requires hundreds of pages, it's for a reason. Now, going back to the outcome, it basically means that it's not a question of if you will be in breach of some part of this or fall afoul of some part of this, but more a question of when and by how much. Now, to answer that, of course, one important step is preparation. As an organization, if you generally know where your data is, you are at least able to discharge one set of obligations very effectively, which is your obligation to provide notice of a breach, your obligation to identify and mitigate circumstances, your obligation to deploy reasonable technical and organizational measures. All of this is possible only if you know where your data is. And as a significant data fiduciary, you are expected to have the size, scale, and sophistication to be able to do that merely by virtue of the size of your data processing.
So just curious. So the question was, it's a following question. Do I have a way of saying then, boss, I didn't know the data I wasn't aware that I had data on tapes. I mean, there is no tool which will tell me there was data lying in tapes. Yeah. So is there a way that people can navigate that from a legal angle?
See, intellectually, if somebody comes to me after the horse has bolted and says, listen, there is a breach, it was lost on a tape, there are legal justifications we can try to construct at that point in time, saying, look, my obligation is not absolute. I cannot protect what I did not know. I exercised reasonable caution. I hired A, B, and C to come look at my systems. This was a repository that was left out. Given that I have a reasonable program and I have complied with it, you can't hold me to an absolute responsibility. But would I hang my hat on it? Would I want to be in that place? No. That is a defensive argument. It's not a. I mean, there are lots we can take, right? Public data exception, voluntary submission. There are lots of arguments we can take if there is a breach type situation. But those are arguments we should take with great hesitation and avoid as much as possible.
So essentially, there's nothing in the law which carves out any exceptions. It's just that we'll have to cross the bridge when we come back. Hopefully, great. I'll just have a follow-on question, and I know Arun, you have a hard stop at 5, so I'll just possibly direct it to you. So we spoke about, should this essentially be sequential? So the point I'm trying to make is there a way, given that we have less than 12 to 15 months, right, for the implementation for this entire thing, which is all the 3 steps, right? Your data security, your DSPM, your consent management framework integration, and there's a lot of work which you'll have to do on your properties to integrate with the framework, get your right consent terminologies, you'll have to do your contracts, you'll have to relook your vendor contracts, employment contracts. So there's a plethora of stuff which you have to do. How should we look about it? Is there a way some of this can be done in parallel, and if I do that, what kind of risks am I exposing myself to if I start doing some of these things in parallel?
Yeah, so I think in this case, perfection is probably not your best friend. I liken it to building a fire. You start with the big logs, so to use CAMS as an analogy, you would look at the big businesses that you are in. That is the processing. Some of that processing, you're a processor, some of that processing, you're a fiduciary. Doing the documentation and mapping for that purpose, as you have done, no doubt, is a great start, which can happen in parallel while you do the discovery for the residual 30%, 40% of your business using a practical tool. The great thing about automated tools is you don't need to have your management sitting in hours and hours of Q&A, putting together Excel sheets to do something and then being questioned and so on. You're not eating up that management and employee bandwidth to do these activities through automated tools. There's obviously some work which has to be done, like false positives and all of that. There's still some activity which has to be done from a validation perspective, but it sort of allows you to parallel process it and run it in parallel. So yes, you can parallel process it, and frankly, given the time period now, that may be the only way that large organizations can actually comply, because manual data discovery is a 6-month exercise. If you start drafting after 6 months, one, you will be behind the curve. And second, your regulator will not be very happy that you have not even started your implementation program on that basis. So showing parallel processing is super, super helpful.
Sorry, before I get on to the next question, we do have time for Q&A at the end. So people who have questions, please feel free to drop your questions on the chat and we'll pick it up at the end of the session. So thanks on that, Arun. And so just coming back to this, and Kaustuv, the question is to you. So we are all talking about this entire data discovery as a starting point for DPDP implementation. But what's also important is that it has to be an ongoing exercise, right? I mean, the law talks about managing the consent and data minimalization as an ongoing exercise. So how should we look about, how should organizations think about this and implement it so that it becomes a continuous process rather than something which you do at the beginning and then manually maintain it? Yeah.
Absolutely. Great question. So I think it works in 2 ways. It's obviously one aspect of it is that it's a starting point. It sort of, you understand where to begin at what to do next. But at the same time, you can, imagine a scenario 3 years later, right? So DSPM is also going to help you understand and have certain evidentiary data over the last 3 years about what was the status in the beginning and how it has progressed. So most privacy laws and all privacy laws tend to have an evidentiary based outlook, especially when it comes from data protection authorities, right? So it's a lot of, hey, I have done this and this is the proof for that, right? So another aspect of this entire exercise is that it helps you much later to have this entire set of data and information and about what you have done, what status it was, and therefore it then helps you build that out. So you have evidence-based answers to, hey, I have built an entire compliance exercise. I want to be compliant. It's a serious matter that something that I as an organization take seriously. So that is where I see most importantly where this framework will play out in the longer run.
So thanks for that, Kaustubh. And just before you go to with it, just a reminder to all the participants, we have a poll. Please do take the poll and questions on the chat, please. Vipindra, I think just coming back to you, there's a common concern which we hear is from the leadership team is the board level accountability under DPDP, right? Now most of these people are a little far away from the day-to-day operations and have no clue as to what kind of data is the organization maintaining, etc. Right, right through to the processor. So how can, as a board or a senior leadership, how can we take steps, and what kind of steps can they take to ensure that the organization is compliant and they are also accountable?
I think it should begin with governance part, and governance can start with showing seriousness about the compliance of DPDP. And so in that context, my recommendation would be that they should start by creating, as we already discussed, a DPDP compliance committee, which is basically the owner of the entire process. And along with this committee, where you have all stakeholders, all internal data fiduciaries, legal team, risk management, and everybody. Apart from that, like we have on board different statutory and otherwise committees, there should be a committee formulated under the board also, which is basically going to work with this DPDP compliance committee, which is the owner of the entire compliance management. And they will basically meet very regularly. And then they both present before the board the progress of the compliance management. So apart from that, there should be a dashboard which DSPM can very well create, which can demonstrate what is happening in real time. So what all we have mapped, what all we have visualized, what all we are doing. And after these three steps, I would say the most important step is education or training of the workforce. I would say entire workforce, but primarily those who are directly involved in this activity tomorrow or even right now. They should be trained about DPDP compliance. So if you club all these activities and then you present it before a regulator in case of a breach also, you have a good case that we have tried to, though that is not going to escape you from penalty, but the quantum and the harshness can be addressed by demonstrating that, see, we educated people, we have seriousness about it. There was a board committee, there was a committee which was overlooking the entire process, and they were, so basically they are accountable. This committee should be directly accountable. Ultimately, board is accountable. There is nothing like can take away this from board. Board is going to be ultimately accountable, but internally that there should be somebody who own it. That if something goes wrong, who is going to be responsible for that, or who can really look into it. So if you club all these things and there is a dashboard where the board is also aware of what is going on. So I think you can demonstrate it well, and this is the way where governance, visibility of dashboard, and the education or literacy of data privacy, because as Arun rightly mentioned that we are in this country, we really don't even know about data privacy. We don't even understand it. Even we don't understand it, even when we are talking. So it is something which is we have to evolve and understand it from a different perspective. The law is made due to maybe the 2017 judgment of Justice Puttaswamy or whatever. I don't know, but I think we will take some time to understand it. And so these are the measures which board can take to show the seriousness. And tomorrow, maybe when everything goes well, this committee can be disbanded or merged with the existing risk management committees. But for the time being, as long as this is not implemented and everything is not set, I think there should be a like two-tier committee plus dashboard plus education, and that is, I would say, equal to demonstrable control.
Interesting. Yeah, so thanks for that, Viminder. And I know I'm just looking at this. So I think I have one more question before we get into the last leg, and that's to you, Arun. So, so I mean, there is this entire the concept of data erasure, right? I mean, once the purpose is fulfilled, then the data has to be erased, right? I mean, but that also kind of sometimes conflicts with your other obligations which come under the other regulators, whether it could be a financial regulator or a SEBI or an RBI or a insurance regulator, or whatever regulation you operate in or you have to keep. So how does that play out? I mean, what prevails, or how should one look at it? Yeah, you're on mute. Yeah.
Sorry, yeah. I was saying, look, it's a constant balance. It's a constant tension, especially since our regulators never really state on record what they want. There's usually almost never written directions saying that you will keep it for forever, which is really what they want, especially if you're a regulated entity. But to answer the question, obviously, if there is a binding, clear legal obligation to retain data or disclose data for a particular purpose, that will override both your retention and disclosure consent thresholds. However, this is not a free pass. If I had a rupee for every time a client has written to me saying, look, Income Tax Act requires that I should keep all my records for 8 years, and therefore my standard retention period for everything is 8 years. I'd be very rich. Effectively, retention periods or statutory obligations for retention periods justify retention for a specific purpose. There is an underlying framework that applies there, which requires obviously that you have some kind of delineation of the environment in which that data is retained. So it has to be secure storage with role-based access. It can't be on your production systems that you are retaining it for legislative, legal, or statutory purposes. Second, it must be protected at a level that is commensurate with the data you're holding. While you hate magnetic tape backups from a convenience standpoint, some kinds of data like long-term litigation hold data, long-term legacy data, which will never go to production, magnetic tape backups might actually be the best way to store them if they're in a physically secure place, which is additional password protection, etc., etc. So yes, you can argue that you have legal obligations to retain it only as long as you have the underlying SOPs and processes in place to actually safeguard that data, and you have a clear obligation in place on record which you can point to and say, look, this is why I held it. What happens in practice, of course, is there are no SOPs. Things are very leaky, and people will just use whatever data is there for things like AI development, training, business improvement, process improvement, grievance redressal, etc. All of these, unless they are clear statutory obligations, which they almost never are, will not be justified on the basis of a legal requirement.
Okay, so that helps. Okay, great. So before we get into the Q&A, I just have one last question, and that's to all the three of you. Please feel free to answer in whichever it is. So basically now, If we have to just decide on what should be how should this journey begin and what should be the priority for organizations for the next 90 days, assuming they have not done anything, they've just heard about DPDP and know what DPDP is, are still planning their implementation journey. And while we talk about DSPM as the first step, what should be your first 90-day road plan for the organizations? And I will leave that question to all the three of you. Please feel free to answer in whatever way. Yeah. Maybe.
I'll go
ahead.
first. I think 90 days is a great period to have a sufficiently clear data map and data inventory of an organization, particularly if you're using automated tools. It may not be the entirety of your organization. There may always be that 20% that you don't get to because they're not responsive or because they're not in a single architecture or whatever else. But 90 days is a reasonable period to develop a fairly sophisticated data map. To your point on parallel processing, it is also a great time to look at the standard organizational contracting, determine whether you're a controller or processor, and start drafting some of the language around it. These are two things you can effectively do within a 90-day period. And to Vipinder's earlier point, it's also sufficient time to put in place your implementation structure and your governance structure to drive the DPDP implementation. These are three things that can happen and must happen in parallel, because you can't really do one without the other. At least you can't do the implementation without somebody to drive it. You can't do data mapping without someone behind it, etc., etc. So I think 90 days is a reasonable period for bridging those three.
Vivinder, Kaustav, you want to add anything to it?
Yeah.
Yeah.
Go ahead.
Yeah.
Thank you. So the way I look at it, just to sort of piggyback on what Arun was saying, is the way I look at it, 90 days is a great period to do three things: plan, assess, and identify. You need to be able to plan as to where, what, who, as Sir said, is maybe have a governance structure, maybe have a board level committee to draw it, or have a interdisciplinary sort of a team to drive it. You need to plan as to who is driving it, what needs to be done, who are your stakeholders, and therefore do an entire planning exercise. That'll essentially prove to be a building block. On the basis of your planning, you will have a much clearer idea as to who will do what and what needs to be done and when. In order to go deeper down into what and when is you need to assess. You need to first understand what you're working with. So assessment will be the bedrock of the DSPM exercise, which will include data identification, data mapping, identifying whether you are a data controller, a data fiduciary, a data processor. Do you have existing DPAs or agreements with your processors? What sort of controls already exists? All that entire assessment exercise can take place, and therefore that ends up with, say, I'll say about a 15-day period of the 90-day period to identify what needs to be done. You'll have a clearer idea as to these are the strong points, these are the weak points. I have high risk areas XYZ, I have low risk areas XYZ. That risk spread is spread between, say, the marketing team or the legal team, etc. So I'll say a plan, assess, identify is a great 90-day framework that'll help you help set context of the entire compliance exercise in the next, say, 14 months.
Yeah, Vivinder?
Yeah. I'll only add that the sequence should be governance before inventory, and inventory before legal analysis, and then legal analysis before controls. So we can divide it into 30 days. First 30 days, you can have your governance and scoping in place. It may take less than that, but let's take 30 days. And then next 30 days, data discovery and mapping. And then next 30 days, legal validation and control implementation. And if tool like DSPM is going to be used, this can be like expedited, and but obviously governance framework need to be in place before deciding on the tools, and who is going to decide on the tools. So governance is required to be at the first place. And I would say while doing automation, human in loop is something required, and a legal advisor should also be there, internal or external, right from beginning. It's not that you create everything and then you bring in somebody for legal advice. It should be parallel and regular exercise.
Right. So if I have to just hear or summarize what the three of you said, for the first 90 days, governance or putting the right teams in place, having the accountability at the right places is a good starting point. Of course, it's common sense, I think. So that's the first starting point. And second, the assessment, like Kaustubh said, which is getting your data, having the tools, start looking at what you have. And like Arun said, maybe in parallel, start looking at your contracts, vendor agreements, start looking at the legal language you want to put where it is, so that at the end of 90 days, you have a fair sense on what are your gaps, and then you can actually go into implementing the framework. So I think that's a good starting point. We are at the end of the session. We'll have a Q&A. So I'll hand it over to you to pick up some of the questions. We can take for the next 5-7 minutes questions, and then we can wind up. Yeah.
Sure. I urge everyone to populate the chat with their questions. One of the questions that's here is, can you name some of the automated tools? Yeah, that's the question from Neha.
Kaustubh, you want to take it or?
I think.
Yeah,
Yeah, go ahead.
I've replied and plugged you, Girish.
Exactly.
No. So there are tools. We have something which CAMS has developed, which we were kind of implementing it in-house, and we have decided that we should expose it to the market. It's called ConsenPro. You can see the logo over there. But yes, to be fair, in the spirit of fairness, there are also other tools available in the market. There are global enterprises like OneTrust, etc., who have their own tools. We also know about a couple of other Indian companies who have, I think, ID5, Legality. So there are quite a few which are available in the market. But our preference is first to evaluate us before you go to anybody else. That's just a marketing plug. Yeah. Meher, next.
Yeah, Arun, there was a question for you which you have answered. I'll repeat the question, but because there's a follow-up to it. So we are an agentic AI legal tech company and using multiple DPAs for LLMs. Does DPDP have extended bandwidth to ensure that providers are also tied to DPDPA for ensuring the compliances? And there's a follow-up saying question is more with liabilities spread to processors as they have closed agreements which have to be agreed before we start their usage.
Yeah, so I answered the first one. Processors, there's a clear imbalance in the power between foundational model providers, large AI providers, and consumers of AI or deployers of AI. The large models and the large providers, LLMs, will have fairly clear playbooks on what. And to be fair to them, they need it given the number of people they contract with. They have some fairly clear playbooks which they deploy to contract, and unless you qualify for a particular threshold in their playbook, they won't cross their internal lines because they have to keep their contracting somewhat coherent. So and of course, like I mentioned, there's no statutory liability, or at least no devolution of statutory liability onto a processor. So effectively, you have to contract around it, you have to negotiate your position and get the remedy you need, or you have to solve for it in other ways. Which can be data quality, it can be de-identification, it can be anonymization. There are technical and organizational measures that you can deploy to minimize the risk that you are subject to.
Okay, the next question. What qualifies as a reportable data breach for asset management companies under DPDP?
If I may just quickly drop in there.
Sure.
A data breach is a very interesting definition under the DPDP. It doesn't say unauthorized access only. It says that a personal data breach is any unauthorized processing of personal data. So the ambit of data breach in the Indian context is a lot wider than what you would see in, say, GDP or a PDPL or any of these laws. Even an unconsented processing of data in this case becomes a data breach, right? So in that case, consent, and therefore ConsenPro, if I myself say so, becomes very important within organizations to understand that all processing happens, whether it's an asset management company or not, if I can be wide about it, is that consent is taken, and also there are evidences to demonstrate that consent was actually taken. So just to answer that.
The next question is, could DPDP slow down innovation in data-driven businesses?
Honestly, if I take that, we have created not a data privacy law, but a economic policy, if I would say. There is a clear carve out for like GCC business in India. If you look at Section 17, you will find that carve out. So the intention is not to hamper the business. The intention is, I think, to do it at least for sake of doing it. I should not be taken like otherwise. I should not be held accountable for this. But government is not going to be, in a way, behaving like in a way harsh on these laws, and they will have to allow some time for us to understand and digest it. And there is a carve out for startups also. There is going to be a separate, in a way, notification for that. So even startups can be like exempted from applicability of DPDP provisions. So that way it is quite flexible. Even for current data which you hold, the consent is reasonably, you have to inform them and reach out to them. So I don't think the intent of government is to be very harsh, except that they have put a 250 crore penalty on the top of it. But otherwise, the intent is not to harm business, and they will come out with definitely clarificatory notes and FAQs, etc. once it is implemented. They have already slowed down, though there is a discussion that they may revisit this 18-month period and they may reduce it to 12 months. So May 2027 can become November 26. But I think government is not looking at it from that perspective.
So, Neha, anything else?
Yeah. There's a couple of more questions. Is there any tool to address the data deletion activity post data asset inventory?
If I can just add a small note, I'm sure there will be tools to deal with how data deletion happens. But usually, when organizations work on more clouds like AWS or Microsoft, etc., there are deletion protocols that you can trigger and you can sort of implement within whatever your overall architecture is, to ensure at least they are deleted. Because these systems have evolved in the GDPR era over the last 7-8 years. So therefore, these aspects of deletion and retention and logging is more or less ingrained within it. I'm not saying that that's the best evidence for it, but if you're looking for a starting point, maybe that can be a starting point for some organizations, especially smaller organizations.
And Kaustubh, I just add on to it. I think the added nuance over here is once we have the consent management framework implemented, there will be a revocation of consent, or there will be a time frame beyond which the consent is not valid, right? And at that point of time, the organizations will have to kind of acknowledge the fact that it is now that they have to actually delete the data which they had taken, or the consent for which the data was taken is no more valid. It could be a marketing communication, it could be anything of that sort, right? So while these tools, like Kaustubh pointed out, there are most of the cloud or on-prem databases or solutions will have tools for deleting data. What is important is you'll have to integrate that with the consent framework, where you will get alerts, or you'll have to check periodically, or there are webhooks which will tell you, okay, this consent is no more valid, which in turn will have to trigger a deletion of that particular record from your database, or deactivation of that record from your database. So that's the way to look at it. So the complexity over there, or the added thing, is you will have to integrate those flows with the consent framework. Yeah.
There's a question that asks, any carve out for MSMEs and small companies?
In the law, I don't know, Vipender or Kaustav?
I think there is a carve out for startups, and then startup definition, if anything is complying with or like falls within that. So that will be covered, and there is a possibility that they may introduce something of that sort for other companies as well. But as of now, there is no redefined term for like that these are the entities which are exempted except GCCs, which is 17 in section 17, there is a carve out for GCCs. So if they are not processing Indian data, they just have to comply with basic security and other safeguards, but they are not as such going to comply with DPDP.
Okay.
The last question, and then we can wrap up. SEBI's 7-year retention rule for AMCs takes precedence over DPDP erasure requests from data principals. How much true is this?
I think Arun answered that. I mean, your regulatory, this thing will kind of override the DPDP thing. If you have a regulatory requirement that you have to retain data for 7 or 8 years, I think you'll have to retain it, but ensure that, and correct, and please keeping honest here, Vipender and Kaustav, you'll have to ensure that it still complies with the privacy protocols, but you may not have to necessarily erase it. Yeah.
Yes, you are right, Girish. Anything which is in a way more stringent than DPDP in any of the laws, existing laws will prevail over DPDP. So it is basically in addition to that, not in suppression of that.
Absolutely. Just to add what sir is saying, is also there's a little bit of a nuance to it as to what can be retained and what has to be deleted, right? So it will entirely depend on the regulatory. So for example, BFSI sector will have a lot more regulations which will come from SEBI that will dictate RBI, SEBI that will dictate a lot more about data retention and data deletion. You look at healthcare, it's going to be an entire different set of regulations, a lot of state regulations as well. What will also have to be seen is granularly seen that what kind of data do you have, out of which for a certain individual there might be 15 data fields, 16 data fields, out of which what need to be retained and what have to be deleted. So there might be some amount of nitty-gritty that will have to also be looked at. Generalistically, yes, if as I said, if it's a more granular law or a specific law, then that will take in general superintendence over the DPDP. But again, there is, in my opinion, there's that granularity to it as well.
Thanks, Kaustav. Meher, before we wind up, quickly run through the poll results. I mean, I don't know how many people responded, but in terms of the posture.
We have 12 responses. We can go over them.
Yeah, please.
Girish,
What
do
is
you
driving
want?
DPDP?
Yeah.
That's okay. So most of the respondents say that what is driving is the regulatory anticipation, which is kind of making sense. Yeah. What else? Just go to the next. It's not sure. So it looks like most people are aware, at least the respondents are aware where the data resides. There's no ambiguity, but I'm sure if once they start doing a DSPM exercise, they will realize there's a lot more than what they thought it is. What is the biggest challenge?
Ownership is not defined. That's the biggest challenge, followed by equal weightage to legacy data and third-party vendors. Yeah.
Okay. And what's the next one? Yeah.
So people are mostly in the policy interpretation
which is,
stage.
I think you're late. Right? Most people are late then. We should be into the implementation stage. Yeah. And lost.
41% people have already started. 16% within 3 months, and 25% don't have a timeline yet.
Okay. Thanks. So it was just interesting to see that. Thank you all, and thank you panelists. I think Arun had to drop off, but thank you, Vipender and Kaustubh, for taking time off and helping us navigate through the implementation stage. I'm sure most of us or most of the participants will find this insightful. Thank you all for taking time on a busy evening and joining this call. I will wind up now. Meher, we can end the event. And
Yeah.
people,
Thank
if
you
you
so
need
much,
anything, you can reach out to us. Yeah, thank you.
Thank you so much. Thank you so
Thanks.
much.
Thanks so
Thank
much.
you. Thanks, man.